Thank you, Your Honors. I will address the Group C questions today. In answer to question CA, we submit that the answer is no. On a literal reading of Article 53(1), the pretrial chamber can carry out an interest of justice assessment where the prosecutor decides not to proceed with an investigation where there are substantial reasons to believe that it would not be in the interest of justice. Article 53(1) does not, therefore, grant the pretrial chamber the power to undertake an interest of justice assessment where the prosecutor decides to proceed. The pretrial chamber here acted ultra vires. The legal representatives of victims, the OPCV and the amici, have provided compelling arguments for why this chamber should find that the pretrial chamber acted ultra vires. We also understand that LRV2 will address this question in more detail today. I will not, therefore, make any further submissions on this point. I now turn to question CB. Should Your Honors determine that the pretrial chamber nevertheless acted within the remit of the statute in carrying out an interest of justice assessment, then we submit that the factors that it considered, the passing of time, cooperation, feasibility, and the resources available to the prosecutor were inappropriate at this stage of the proceedings. The reasons for why these factors are erroneous are explained on pages 30 to 39 and 45 to 46 in our appeal brief. If the four factors of passing of time, cooperation, feasibility, and resources are to be considered appropriate, then the pretrial chamber failed to properly carry out the balancing exercise required under Article 53(1)(c). A proper interest of justice assessment must balance those four factors against the factors mentioned in Article 53(1)(c), the gravity of the crimes and the interests of the victims. In our submission, a proper interest of justice assessment must be informed, comprehensive, and holistic, and it must genuinely appreciate the interests of the victims and the gravity of the crimes. It must also recognize the presumption for an investigation. A proper assessment would have taken into consideration the impact of the alleged criminal conduct of the anti-government forces, the Afghan government forces, US forces, and other international forces, on the victims, but also on their interests, and it would have weighed their interests against the four factors considered by the pretrial chamber. These interests include, in a broader sphere, access to education, the practice of religion, access to healthcare, and access to justice. For millions of Afghans, the crimes under consideration have had a devastating impact on these interests. Furthermore, a proper assessment that genuinely considered the interests of victims and the gravity would have reflected the physical and psychological impact of the crimes, in particular sexual and gender-based violence on an unknown number, but very likely hundreds of thousands of Afghans. Almost every Afghan is a Muslim. Salah, prayer, is a physical, mental, and spiritual obligatory act of worship and a key pillar of Islam. In particular, Salat al-Jama'ah, prayer in congregation, is looked upon by Allah favorably, and it is rewarded. Attending mosque to participate in prayer in joint congregation is sacred to millions of Afghans. But their ability to attend mosque has been devastated by attacks against mosques and other places of worship. These have become a regular feature of the conflict in Afghanistan. One of the victims that we represent lost her 14-year-old brother in a suicide attack on a mosque, allegedly involving Daesh. She, her father, and two brothers were peacefully exercising their right to worship. Another victim that we represent has said that she cannot forget the loss of her husband, the father of their 4 small children. He was killed, also in a suicide attack on a mosque. She's explained that they're in need of food, shelter, and access to education. The father was their breadwinner. As has been well documented, the Taliban systematically oppressed Afghanistan's women and girls. One of the most destructive abuses of women under the Taliban was the denial of education. The consequences of that denial is felt today. The female literacy rate today is approximately 30% only. The effort made to enroll girls into schools has not been easy. Insecurity and violence stemming from both the ongoing conflict and general lawlessness is resulting in low attendance and poor education. The bombing of schools and the occupation of the schools by the Taliban and Afghan government forces is a regular occurrence. Afghans' access to health care is also severely hampered by the commission of the alleged crimes before this court. Hospitals, clinics, and other healthcare facilities are systematically attacked. According to the World Health Organization, in the first 6 months of 2019, 68 attacks on healthcare were reported, resulting in the closure of 101 health facilities. As of August 2019, only 27 of those have been reopened. There are already not enough healthcare facilities accessible for Afghans in need. The destruction and closure of healthcare facilities put Afghan lives at risk. This include women in need of maternal care and child care. In 2018, UNICEF stated that newborns in Afghanistan face the worst odds. According to UNICEF, Afghanistan has the 3rd highest newborn mortality rate in the world. The chief executive of Afghanistan, Abdullah, a medical doctor himself, said recently, quote, "With what we spend on a single day of war, we could build a state-of-the-art hospital," end of quote. The crimes against Afghans are not only having disastrous consequences on the physical health of Afghans and their access to physical health care. The mass victimization of Afghans is resulting in a mentally unwell population. It is estimated that half of the population of Afghanistan suffer from depression, anxiety, and post-traumatic stress. The impact of this on the general well-being of an individual Afghan, but also on their relatives, friends, communities, and the country of Afghanistan as a whole cannot and should not be underestimated. In 2010, the family of several victims that we represent were celebrating the birth of a baby boy in accordance with Afghan tradition. Everyone was enjoying themselves when they heard someone yell outside, "Raise your hands." One of the men at the party, a police investigator himself, went outside and was shot on the spot. His 16-year-old son, upon hearing the scream of his father, ran outside. He was also shot. The brother of the police investigator was in the house. He was a prosecutor. He tried to run outside to rescue his relatives. The female relatives held him back, tried to stop him from leaving the house, but he pulled away from their grip and made his way to the doorway. He was then shot himself, as were the women. 2 pregnant women and 1 teenage girl, as well as 2 brothers and 1 teenage boy, were seriously injured when international special operations forces entered the gate of the home. For hours, special forces searched the house meticulously. As the pregnant women, teenage girl, teenage boy, and brothers lay wounded. The 2 pregnant women, the teenage girl, and the brothers, one by one, succumbed to their wounds, as the armed forces refused to let their family members seek medical help. Immediately thereafter, the International Special Operations Force issued a statement in which they claimed to be doing a raid on the house, and during the raid had found the women and the girl already dead. They explained that the girl and the women had been killed in an honor killing before their entrance to the house. Investigative reports and those present compelled the International Special Forces to admit that the women had actually died during the operation. These victims are to this day waiting for justice to be served. Generations of Afghans are unwell. They're brutalized by a multitude of actors in many different ways. In one night, in this incident, surviving mothers, brothers, sisters, daughters, and sons were irreparably traumatized, some of which had watched the pregnant women, the brothers, and the teenage girl die, and pleaded with the special forces to get them help. But also, after they had deceased, they had pleaded for their bodies to be treated with respect. This did not happen. A proper assessment that considers the interests of the victims would also consider the killings of judges, police officers, and prosecutors. Deliberate attacks against these civilians that uphold the law have been presented by the government of Afghanistan in their submission of 2 December 2019. These attacks are a clear reason for why this chamber should reverse the impugned decision. No matter how willing Afghanistan is to investigate and prosecute war crimes and crimes against humanity, it is simply unable to do so. Human Rights Watch has confirmed this in its 2018 report on civilian airstrike deaths. Quote, "The Afghan government has developed almost no capacity to investigate civilian casualties arising from its military operations." End of quote. As we have submitted in our appeal brief, the pretrial chamber's assessment of the resources available to the prosecutor was erroneous. The pretrial chamber's assessment of the prosecutor's resources represents an unwarranted invasion of the prosecutor's competence to determine how best to allocate the resources available to her office. However, if your honors find that it is within the powers of the pretrial chamber to carry out an interest of justice assessment, and that as part of that, assess the resources made available by the state's parties, the assessment that was carried out was partial and incomplete. A proper, holistic assessment would have taken into account the resources which have been invested in Afghanistan since 2001 to seek a military solution to the conflict and reconstruction of the country. Conservative estimates suggest that the US alone has spent $975 billion on the war in Afghanistan since 2001. Despite the colossal resources that have been deployed into Afghanistan seeking a military solution, the results have fallen short of any expectations. A United States government agency, the Special Inspector General for Afghan Reconstruction, also known as SIGAR, stated in late 2018 that, quote, "The Taliban now controls more territory than at any time since 2001, end quote. In January 2018, BBC estimated that the Taliban had an active and open presence in 70% of the country. SIGAR has also estimated that since 2001, the US has invested approximately $113.1 billion in Afghanistan reconstruction. Adjusted for inflation, that is $10 billion more than what the US committed in civilian assistance to help rebuild Western Europe after World War II. Despite these huge investments, insecurity reigns, as we see from the submissions by the government of Afghanistan. According to UNAMA, more than 27,000 Afghan civilians have been killed over the last 10 years, and more than 51,000 Afghan civilians have been injured in hostilities. In the first 9 months of this year alone, 2,563 Afghan civilians were killed, and a shocking 41% of these were women and children. A proper and holistic interest of justice assessment would have addressed ways in which the state parties can devote more sums to international justice. The prosecutor can at any time submit a supplementary request for resources to the Assembly of States Parties. And as Mr. Schaffer suggested in his 15 November amicus curiae observations to this chamber, the appeals chamber is also in a position to call upon the states parties to make available the necessary resources. To conclude, Your Honors, rigorous investigation and prosecution of crimes is one step to ensure greater respect for the rule of law in Afghanistan. A strengthened rule of law is surely likely to, in turn, ensure a more genuine realization of the victim's interests. Thank you, Your Honors. I'll now give the floor to Mr. Gaynor.
Thank you very much. Your Honours, I will not address in very great detail the question as to whether the pre-trial chamber erred in restricting the scope of the prosecutor's investigation in light of Ms. Brady's submissions today. We agree really with almost everything that she said. We would add to what she said that both the prosecutor and the chambers have truth-seeking duties under the statute, and the ability to seek the truth is obviously easier to carry out when the remit of the investigation is broad than when the remit of the investigation is narrow. We add to that the fact that the prosecutor is obliged to uncover both incriminating and exonerating evidence. And again, it's easier to find and identify witnesses and to pick up documentary evidence and all other kinds of relevant evidence where the remit of the investigation is broad rather than narrow. I'd like to take this opportunity to address some of the submissions made by my learned friend, Mr. Dixon, on behalf of the government of Afghanistan, and some of the submissions made in the written submissions of the government of Afghanistan. Mr. Dixon gives the impression, if I might suggest, that the government of Afghanistan has been shut out of the preliminary examination and nobody wants to listen to what they have to say. Well, my understanding from reading the prosecutor's preliminary examination reports, which are released about this time every year, is that the government of Afghanistan has in fact been in constant contact with the prosecutor, and the prosecutor has very properly asked the government of Afghanistan to let it know what it has been doing in respect of the investigation and prosecution of crimes within Afghanistan. And so there really has been every opportunity. The preliminary examinations report for 2016, for example, refers to the Office of the Prosecutor said that the government has not provided any information of national proceedings to the office against Afghan government forces, despite, quote, multiple requests for such information from the OTP since 2008, end of quote. That's the preliminary examination report of 2016. So really the government of Afghanistan has had every opportunity to bring before the Office of the Prosecutor, and in turn through them to the pre-trial chamber, its information concerning the investigations and prosecutions that it's carrying out in respect of alleged crimes by its own forces, by international forces, by Taliban and associated groups, and by ISIS. Now, Mr. Dixon would like us not to get into the detail of Article 17.2 and 3, but frankly we have no option given that, in particular, our ability to respond to these issues tomorrow has recently been ordered by Your Honours off the calendar. So I have no option but to respond today. Now, 17.2 of the statute concerns where there has been unjustified delay in the proceedings, which in the circumstances is inconsistent with an intent to bring the person to justice. That is absolutely relevant. Mr. Dixon refers to the 11-year period of the preliminary examination and says, well, too much time has passed, it's now time to move on. Well, that's absolutely contrary to the victim's interests. There is no statute of limitations in respect of war crimes, crimes against humanity and genocide. It is absolutely in the victim's interests that the investigation and prosecution of these matters should take place. Another question to be considered here is the I'm still on willingness, the willingness. Is Afghanistan willing to carry out investigations and prosecutions? This is particularly important in respect of two groups of people. The first is Afghan government forces, and the second is international forces for crimes against Afghan civilians on the territory of Afghanistan itself. In respect of the Afghan government forces, these are paid by the government of Afghanistan, they're fed by the government of Afghanistan, they are housed by the government of Afghanistan. The government of Afghanistan certainly has access to these individuals. It has its own military justice system, and yet in all of the oral and written submissions by Mr. Dixon and by His Excellency the representative for the government of Afghanistan, we see one reference to one prosecution of one case against one member of the Afghan government forces, and that relates to the murder and rape of a boy. Now, that single example, absolutely fine, it's good that that took place, but that is not indicative of a genuine willingness to investigate and prosecute crimes by Afghanistan government forces generally. Second, we've seen no indication from the government of Afghanistan of a willingness to investigate crimes allegedly committed by international forces on the territory of Afghanistan against Afghanistan citizens. Then we have to move to 17.3, and this concerns inability. Mr. Dixon essentially characterized the 17.3 test as, is Afghanistan a failed state or not? And with respect, that is not the test set out in 17.3. 17.3, the first part of it, I'll read it verbatim, quote, in order to determine inability in a particular case, the court shall consider whether, due to a total or substantial collapse or unavailability of its national judicial system, and I'll stop there for a moment, what we do have in Afghanistan is a substantial collapse or unavailability of the national system. And that's absolutely clear from the submissions made on the government's behalf today. And it's also clear from some of the submissions which were made in the report of the government of Afghanistan itself. The government said, for example, at paragraph 24 of its submission of the 2nd of December 2019, it said, quote, the reality is that Afghanistan remains in the middle of a brutal armed conflict marked by guerrilla warfare and suicide bombing. They go on to say, attacks by the Taliban and other armed groups continue to cause heavy casualties. As a result, there are many parts of Afghanistan in which it is simply not safe to conduct investigations, close quote. Now, the government has referred many times, and my colleague Ms. Kiswanson earlier referred to the murder of police prosecutors and judges in Afghanistan. So all of these factors must be taken into account, and I think the conclusion which we must all, with great regret, reach is that there has been a substantial collapse and unavailability of the national judicial system. Now, I just want to carry on reading from the test set out in Article 17.3 of the statute. The test goes on to read, quote, "The state is unable to obtain the accused or the necessary evidence and testimony or otherwise unable to carry out its proceedings." And again, I would refer to the written submissions of the government of Afghanistan. And in those written submissions, I don't have the precise quotations to hand, but it is quite clear that the government of Afghanistan, its own position is that it is not able to access suspects and accused on its own territory for the very reason, as has been pointed out by many, is that the Taliban itself controls a significant proportion of the territory of Afghanistan. The non-control of a significant proportion of the territory of the state party in this question, when assessed in combination with the systematic attacks on police, prosecutors and judges, means, in essence, inevitably and very regretfully, that the necessary evidence and testimony is simply not available to the government of Afghanistan in order to carry out its proceedings. Now, what is the procedural remedy for all this? The procedural remedy is for Afghanistan to bring an admissibility challenge at the correct moment. That we can then have a full hearing. I'm not asking Your Honours to conduct an admissibility challenge right now. But the right thing to do is for Your Honours to authorise the commencement of the investigation on the basis of the findings by the prosecutor that the Afghanistan is both unable and unwilling to effectively investigate and prosecute. And then Afghanistan can bring a proper admissibility challenge. It can bring to the court clear evidence of a genuine, not just willingness, but an ability to investigate and prosecute its own forces for crimes committed against Afghan civilians. It can also bring evidence, which has been absolutely absent so far, of its own willingness and ability to investigate and prosecute international forces for crimes against Afghan civilians. And it can also make full and informed submissions concerning whatever proportion of the territory of Afghanistan is at that time under Taliban control or under the control of other anti-government forces. So I would suggest that that is the proper procedure to be followed. Mr. Dixon and the representatives of the government of Afghanistan can then come back before the pre-trial chamber and make full submissions on admissibility. I don't believe I have anything else to add. Thank you very much, Your Honours.